Sharon and June have been longtime members and supporters of this council. They are exceptional attorneys, and our community is really fortunate to have them working with the kind of work they do. You're going to be learning more about that right now. Please join me in welcoming Sharon and June.
June and I are really happy to be here. We love doing domestic violence work. We love doing misdemeanor domestic violence work. And what we're going to be talking about this morning is prosecuting misdemeanor domestic violence cases. And I think June and I would agree that prosecuting a misdemeanor domestic violence case is the most difficult task a prosecutor can have. And we're going to start out this morning by showing you a video, and I want to give you a little background as to what this, where this video came from. About 3 years ago in Long Beach, we had a terrific idea, because at that time we could bring in victims' testimony, even if we did not have a victim in trial, to establish our case. And also because so many victims recant and say something entirely different when they get on the stand than they said at the time, we thought it would be what a wonderful idea to give video cameras to police officers when they respond to a domestic violence call, to videotape the victim at the time when she is speaking to the officer, so that we could show that testimony to the jurors when we get in trial and the victim is totally different. Well, we bought a couple of cameras, we gave them to the sergeants. They tried it for a couple of times. It was very, very difficult, and ultimately they decided they just couldn't do it. There was too much for the sergeants to be doing at the scene. It was too cumbersome, it was too intrusive. Because they're on the other end of it, they don't see this tremendous value. But during the very short period of time that we were doing it, we ended up with this one really wonderful video, which is very edited down. You were going to see the victim at the location where she was assaulted. You will see her at the hospital talking to the officers about what happened to her. And then you will also see what the jurors see during trial. And you can see that this is what we face as prosecutors and why getting a conviction is so different when all that the jurors see is the victim at trial. And so I'm going to attempt to start this. I think you will be able to see it better if we can get the lights turned off.
She's repetitively saying to them, and he's in jail for something he didn't do. And that's all they hear. They don't get to see what happened at the scene. The injuries are healed. You hear about their love, which is very real. And all you get to hear is, I was drinking and he's in jail for something he didn't do. It's a very difficult job, misdemeanor prosecution of domestic violence. And you know that by the time it gets to the level of calling the police, this person has been a victim for a very long time before it's the straw that breaks the camel's back. And people are so afraid. They're so afraid that they'll lose their partner, that their children will get taken away, that they'll lose their home, that they won't have any money, that they don't know how to work. There's so many things fighting against us in our job in trying to intervene in a family. The only way through our process that we can intervene is if there's a conviction. And we realize that jail is not the answer. By intervening, we're able to get them to you guys, into therapy, by getting the children help, by getting the survivors help, and the perpetrators. While Sharon's getting this ready, I want to take a small moment to talk about a new friend of mine who's here today and stood up and introduced herself as a survivor in the front, Angie. And she's going to put a smile on all of your faces because, to me, she is a prime example of why we do what we do. Angie, as a child, from a home of domestic violence. And in the classes that or the meetings that we've had here, we've learned about multiple diagnosis families. There's alcohol abuse in her home. She's recently learned that her mother is developmentally disabled and has a level of about an 8-year-old. And she has survived this, and not alone, with a lot of help and a lot of therapy. But I'm very proud to tell you that thanks to the help of financial help of someone named Rosie O'Donnell, she just graduated UCLA. And even more, she's been accepted to Bolt Law School. And just even visiting this morning, and we visited on the phone just maybe a handful of times in our knowing of each other. But I asked her this morning, I said, why was there not intervention? And she said, well, we lived in the projects, and it wasn't unusual. The neighbors were doing the same thing that my parents were doing. Nobody reported it. She was one of the very lucky ones. She has a high school teacher who broke the rules, risked herself, and took this young woman in, saw potential, and has guided her and has had her living in her home this entire time. Now, something that she's dealing with right now, which I want to pose the question to you, is that she does have this mother who is developmentally disabled, and we're at a point in prosecution now where her father needs to come back to court. And as you'll learn today, we will need her mother in court, who will not come. And so if any of you see her up in the front row here and you have any suggestions where she could get some therapy for her mother, as I said, she's about eight years old mentally, and she is a survivor and still a victim, Spanish speaking, I believe. She could really use a hand in trying to find some aid for her mother. But I'm just so proud of her, and look forward to all the wonderful things that she's going to do in life, because she feels very dedicated to our community of people intervening, and plans on, I told her not to cement herself, but plans on dedicating her life to helping other children who've survived this. So now, as our presentation is ready, and when the meeting's over, if anyone has anything for her, she's here in the beautiful beret.
I was just saying, if there's anyone who wanted to make a comment about the video, Paula leaned over to me while it was playing and said she's so good she looks like an actress, and I agree. It looks like it's a production, a television production, because she's such a classic recanter, complete with body language and everything. Yes.
What I was thinking was, even if the jury didn't listen to the words, she was so hostile that they would lose all sympathy for her. So it really showed to me how difficult your job is.
Thank you.
I think that a lot of times jurors are feeling, well, if they don't want to help themselves and they don't want my help, why should I help them?
Okay, we'll go ahead and start this.
It's a small poem which kind of, we feel, indicates why we do what we do, entitled Flowers. I got flowers today. It wasn't my birthday or any other special day. We had our first argument last night, and he said a lot of cruel things that really hurt me. I know he's sorry and didn't mean the things he said, because he sent me flowers today. I got flowers today. It wasn't our anniversary or any other special day. Last night he threw me into a wall and started to choke me. It seemed like a nightmare. I couldn't believe it was real. I woke up this morning sore and bruised all over. I know he must be sorry, because he sent me flowers today. I got flowers today, and it wasn't Mother's Day or any other special day. Last night he beat me up again, and it was much worse than all the other times. If I leave him, what will I do? How will I take care of my kids? What about money? I'm afraid of him and scared to leave. But I know he must be sorry, because he sent me flowers today. I got flowers today. Today was a very special day. It was the day of my funeral. Last night he finally killed me. He beat me to death. If only I had gathered enough courage and strength to leave him, I wouldn't have gotten flowers today.
June and I both have done misdemeanor only, domestic violence prosecution. So what I'm going to be talking about is the prosecution of misdemeanor domestic violence. Misdemeanors are the lesser serious, the more serious crimes are the felonies. But I want you to know that in Long Beach, as I've harped on before, 95% of the cases in Long Beach are filed as misdemeanors. Only 5% are filed by the district attorney's office as felonies. Anywhere else in the state, the statistics are closer to being reversed. In Orange County, almost everything is filed as felonies, but in Long Beach, we handle almost everything. So our cases start out, and I'm having trouble with the little remote, so I'm just going to try to do it with this. Most of our cases start out with a 911 call. Oftentimes it's by the victim, but it can be a neighbor hearing the fighting, anybody who thinks there's a problem. For those of you who don't know, the 911 calls are saved for 6 months. And it's a very important piece of evidence to bring in trial, because when the victim's recanting in trial, we can bring in the 911 call and say, well, this was you screaming. And a lot of times we hear the defendant screaming, or actually maybe even choking her in the background. So we do get the 911 calls. Once the 911 call comes in, the police respond. The officers take a report. If the batterer is at the scene, and if the victim has any visible injuries, they have to make an arrest. A lot of victims still don't know that. All they want is for the officer to come out and calm things down, maybe make him leave. But if the victim has any injuries, they have to arrest the batterer at the time. In Long Beach, the bail for domestic violence is $50,000. Anybody who practices in Long Beach knows that. I'm talking about defense attorneys. Anybody who doesn't practice in Long Beach thinks that that's absolutely outrageous, because bail in other counties might be $15,000 or $25,000. But it's very, very high in Long Beach. And the realistic matter is that most people cannot afford to bail out with a bail of $50,000, which means that they stay in custody until their case is resolved. The officer goes back to the station after he's interviewed the victim and any other witnesses who might be there. He writes up his report. The report is forwarded to the domestic violence detectives unit at the police department, and they process the paperwork and they send it to my office. In June's case, it's the Los Angeles Police Department, and they send it to the domestic violence detectives in the LA City Attorney's Office. And they process the paperwork and send it through to their domestic violence unit, who decides whether the case is going to be filed or not. And we're going to be talking again here about the cases that are filed. If the case is filed, the person who is in custody is brought to court within 72 hours for his arraignment. If the batterer is gone by the time the police get there, which often happens once he sees that the victim's calling the police, he's out of there. He knows what's happening. The detectives or the police officer also goes back to the department, writes up the report, and the report again goes to the detectives in the domestic violence unit. They, as soon as they can get to it, which might be anywhere from 2 weeks to 2 months later, they process the paperwork, and it comes either to my office again or to June's office, to the prosecutors to decide whether we're going to file a case. Now, my office differs from June's a little bit. In my office, we do not send any letters out on domestic violence cases. If a case is going to be filed, we file it with a warrant. And so it's not uncommon to have an incident happen. Let's say, for example, an incident happens in June. The guy takes off, so he's not there when the police arrive. She talks to the police. The police go back and write up the report, and it comes to me. I file the case. The warrant goes into the system, and the warrant just sits there in the system because it's a misdemeanor. And there are so many warrants out there that the warrant detail in the police department doesn't have enough people to work the misdemeanor warrants. So maybe 5 months later, they get pulled over for running a stop sign. The police officer runs his name in the computer system, and lo and behold, there's this $50,000 warrant in the system, and he gets arrested. And in the last 5 months, they've, of course, gotten back together. They're in love. Everything's wonderful. They're happy. She doesn't want to prosecute. She maybe doesn't even hardly remember making the report, and everybody's mad because now we've got him in jail, and we're prosecuting him for something that happened a long time ago. It was just a big misunderstanding, and everything's fine, and everything's wonderful. Sometimes we send cases back for further investigation, for the detectives to talk to other witnesses, and sometimes if there is not enough evidence, we do reject cases.
As Sharon was saying, things are a little different in the LA City Attorney's Office. We do send letters, and I understand the Long Beach City Prosecutor's reasoning that it could cause a victim a safety issue by sending a letter to the home. But because we know that people do not go out, officers do not go out on misdemeanor warrants, we do send a letter to the perpetrator asking him to come into court. A lot of times they come, a lot of times they don't come. But once the letter's been out, then the court, if he doesn't appear or she doesn't appear, the court will issue a bench warrant. And we use their most current address, usually where they were living with the victim, and therefore they have some notice that there's a warrant out for their arrest. In addition, in our office in LA, we have something called city attorney hearings. And usually when there is an incident where the police are called, but there are no witnesses and there are no injuries, you still want to try to intervene in the family. And so we have a hearing office where the people are called in, they're offered assistance, they're given information on intervention programs, and they are also warned about what will happen in the future if it were to happen again. There are formal reports taken of the hearing and the officer's findings. If he finds out more information that the police didn't know, he can refer it back to the city attorney's office for reconsideration for filing. Or all of these reports are maintained so that in the unfortunate circumstance, but the likely circumstance that there's another incident, that we have corroborating evidence of previous bad acts. As Sharon said, in the city of Long Beach and in most cities, most domestic violence cases are prosecuted as misdemeanors. And we talk about what is the difference between a felony and a misdemeanor. And the things that we see that is considered misdemeanor behavior is shocking to the conscience. There has to be, for the district attorney to accept a domestic violence case and prosecute it, some heinous injury which will make you gasp. We see...
I don't want you to think that every heinous injury that makes you gasp is filed as a felony. We file a lot of heinous injuries that make you gasp as misdemeanors.
Hair ripped out, teeth knocked out, fingernails pulled off, gashes, hematoma bruises, people holding their children while this is happening to them. And it comes to us as a misdemeanor. For a felony, they look for prior convictions, serious injuries, which usually involves stabbing, broken bones, permanent injury, prior felony convictions. And as you can see from the slide, things like property damage, throwing all the furniture around, threatening phone calls, stalking, violating a restraining order, that little piece of paper which is supposed to protect your safety, and a first-time offense. These are things that come to our offices in the city prosecutor and the city of Los Angeles city attorney's office. And there is a situation sometimes where we can ask the domestic violence detectives to take it back to the district attorney. But it's a rare time when, after reconsideration, that they take it. There must have to be some new fact revealed that they didn't know before. Yes?
Yeah, I'm going to let June do it because I'm going to say something really mean.
The standard required to prove a case to a jury is beyond a reasonable doubt. And that's not beyond any doubt. But if you were, I didn't bring my puzzle box. If you have a top of a box of a puzzle, you understand what the whole picture is going to look like when you put it together. And if there are a few pieces missing, you still know that it's a wagon wheel on a water thing with water flowing over it, and you still get the whole picture. But if there are more important pieces missing, you have to consider whether you can prove it to a jury beyond a reasonable doubt. You put that together with the fact that if you take people to trial and you don't have the ability to prove it beyond a reasonable doubt, first, you're forbidden to file it ethically. Second of all, it costs the taxpayers a ton of money. And third, politically, it brings your conviction rate down, which makes you lose the next election.
Yes.
Yeah, I'm compelled to offer a response to your question, Michelle. With each passing day, for me, my view, the imbalance between the masculine and the feminine consciousness on the planet, I don't know the truth, but my sense is that it's probably the fundamental reason for every kind of abuse that occurs. If it were the men who were being abused this way, I believe the procedures would change. I think the laws would change. Very striking to me how the victim went into a masculine consciousness and her behavior changed so much from when she was a victim. She was vulnerable. But there's no power in that on this planet. And also she, and this is just my view, she identifies with the perpetrator. It was like that was the perpetrator sitting on the stand. That's the reality. It's fundamental, not just between us, but within us, the lack of balance between the masculine and the feminine. And I'm not blaming anybody. It's my responsibility as well as anybody else. I believe it rests with everyone.
Okay, we'll keep going. One other reality, Michelle, is that the district attorney's office, you live or die by your conviction rate. You go up according to your conviction rate. I don't want to say anything bad about the district attorney's office, but you know, the way we think of the DAs is they will only file a case if they have an eyewitness, a written signed confession, and six witnesses to it, and they file cases that they are absolutely sure they can win because their promotion rate depends on their conviction rate, and it's very political, and it depends a lot on the person who's running the office, and it's just really a shame, the situation that we have. Misdemeanor injuries. These are the things that we see that we file on regularly: bruises, scratches and cuts, redness from being slapped, lots of swollen and cut lips, black eyes, bloody noses. Those are your garden variety misdemeanor injuries. Okay, a typical case might start out with Friday night, somebody goes out drinking with the guys after work. He gets home, they get into a fight. She's upset, she's scared, she calls the police, the officer responds. He's there, the officer arrests him, takes him into custody. Well, what happens in between Friday night when he's arrested and Monday morning when her husband is brought to court? he gets sober and he calls her on the phone and he cries on the phone. I'm so sorry, honey. I love you. I promise I will never take another drop of alcohol. I will never hit you again. I will never drink. I will go to church with you. We will go to counseling. He sends her flowers. I love you. What's going to happen to you if you make me stay in jail? You and the kids have nowhere to stay. You're going to be out on the street. Please, honey, go in and tell him that you don't want to prosecute on this. Help me get out. I'll come home. I'll do anything that you want. And so Monday morning, when I see her, she is really upset with me because I am prosecuting on this case because over the weekend she has seen the wonderful guy that she married. Okay, the victim at the misdemeanor stage, 95% of the time, she is not ready to go to a shelter. She is still in denial that her husband has a problem with any violence. She'll deny it to us. Usually she will say that she started it, she was drunk, she's bipolar, she takes medication and she forgot to take her medication. He never hit her, she slipped and fell and hit her head. You name it. She's either completely recanting, she lied to the police, or the police lied in their report. One of the two, somebody lied, and she's very angry that we won't drop the charges.
Next slide. As we were talking about the filing considerations that the misdemeanor prosecutors take into account, we look at the 911 call. We want to know who made it. Are they willing? Did they identify themselves if it's not the victim? What was said? Is there details as to what happened? Were they crying and upset and angry and scared, or were they calm and it's been a couple hours? Has it been 5 days since it happened and now they're looking for some revenge, or he didn't give her money to go shopping? Were there spontaneous statements made to the officers or to the 911 operator, not in response to a question, just spit out of the person's mouth that are very strong evidence? If you have all of these things, and she comes into court, or he comes into court, excuse me for the sexist comment, and they come into court and they're recanting, if you have all of that strong evidence, we can still prosecute. But if you don't have all that, you have to think about it when you are filing, because if you don't have it and she doesn't come in telling the truth, you can't prove it beyond a reasonable doubt. Yes, Paula?
So I have to ask you about your allegedly sexist comment, because it seems to me from working in the clinic that the guys who try to get restraining orders always show up to court, never change their story, and they're very insistent that they're going to go forward. And I'm curious, in the criminal world, is that true in misdemeanor prosecutions also, or not so?
We handle gay couples, straight couples, male victims, female victims, and it's really a case-by-case thing, not really stereotypical as to the package that your survivor comes with, what kind of baggage they have coming with them as to how they're reacting.
But if we're talking about a heterosexual relationship where the guy is asking for the restraining order, does he recant in the same way that women do?
I found that most of the time when I have a male victim, he comes in recanting, which is even more difficult to prove because he's the big guy. Now you know why he recants. Because she's in jail, nobody's taking care of the kids. He's got to get up in the morning, he's got to feed the kids breakfast, he's got to get them off to school, he's got to, all of a sudden, the tremendous responsibility for taking care of the children is on him, and he doesn't want that. He wants her home, cooking dinner, feeding the kids.
A lot of the time, he is in reality the abuser. And this is just the one time where she got up the strength to fight back. And he called the police. So, click, please. We'll click again. Oh. Yes. As we were discussing, and I really love to use my puzzle analogy, and when I do a jury trial, I actually bring a puzzle in, or I talk about the puzzles in the jury room that hopefully when all of you have had the privilege and the responsibility of serving on a jury, you've had the chance to make those puzzles, and you see that there's always pieces missing, but you still know what it is that you're making. And that's the analogy I like to make to a jury, is that you still know what it is, even if there's a few pieces missing. You're sure of what that picture is beyond a reasonable doubt. Because the defense attorneys are arguing all these red herrings to the jury of things that they don't know. But they still know what happened, even if they don't know what color shirt she was wearing that day because the little puzzle piece is missing. So the whole thing that we as prosecutors need to always keep in mind is, do we have enough evidence so that they know what kind of a puzzle all this evidence is putting together, what the final picture is?
Okay, getting down to what happens in court. The first time the defendant is brought to court is called the arraignment. It's when he is advised of the formal charges that have been filed against him. In our office, we have our victim advocate, Alicia, who tries to get a hold of the victims each morning of the people who are in custody to tell them the prosecutor would like to talk to you, please come to court. We tell them that there is a no-drop policy. I know you don't want to prosecute. You're not prosecuting. I am. We don't drop the cases. We have a chance to talk about if the defendant wants to plead to the case, what his sentence will be. If he pleads guilty, he's sentenced. And if he pleads not guilty, then bail is set. And again, bail in Los Angeles County is $50,000 for the 273-5. The victims are always ordered to return. It ends up being a burden on the victim, but it's the only way that we can keep jurisdiction over the victims. So we have to have them ordered back for each court date. And if the victim is not there, a protective order is always issued, and it's a complete stay-away order, ordering the suspect to have absolutely no contact with her. If he is able to bail out, he can't go home, even if she invites him to go home.
And the city of Los Angeles also has a no-drop policy. However, I admit here that I'm a little bit of a white liar, because I do ask victims to come into court who want to drop cases. And I'll say I'll talk to them there and they can talk to the judge, because I want them to come to court so that I can intervene and speak with them, so that I can serve them with a subpoena personally and keep them coming to court, so that I can do everything that I can to try to flip, as we say, or gain their cooperation so that they realize I'm not the enemy, but I'm someone who's sticking out a hand for them to grasp. And that over the phone just doesn't work. If you could click, please. After the arraignment, where everyone's pleading, well, not everyone, some people want to get out of jail immediately, and they'll take the responsibility for everything, not realizing that they'll be going to counseling for a year. But the people that plead not guilty come back in a week or two for their pretrial hearings. And at that time, the victims are subpoenaed to court to appear so that we can hear both sides of the stories and know what kind of people we are talking to see if they're convincing to a jury, if they have substance abuse problems, if they need a victim advocate to help them find services. And the matter, if the matter is continued without a plea, it's set for trial. We share evidence at that time with the defense. We look at photographs, listen to tapes, and everyone kind of knows what's on the table as far as going forward for trial. Click, please.
Okay, if a case hasn't settled, then it finally does get set for trial. If the victim hasn't shown up yet, we do have our investigator go out and personally serve them with a subpoena. If they don't appear, we have the judge issue a body attachment, which is like a warrant for the victim, and then we send them a letter that says, there is a warrant out for you, please come to court. I'm not going to get into the whole issue of should we or should we not arrest victims who don't show up in response to a subpoena. That's a 2-hour discussion in and of itself. But we have the ability to do that. It's also sometimes the first time we have a chance to look at the photographs, hear the 911 call, showing the defendant the photographs and letting them hear the 911 call oftentimes will encourage them to enter a plea. During the trial, right now we have to have victims at trial because of a case that came down from the United States Supreme Court a couple of years ago, Crawford versus Washington, which in all of their wisdom, the United States Supreme Court said that an accused has the right to confront his accuser, which has taken away our ability to try a case unless we have the victim there. So it's put a tremendous burden and dent on domestic violence prosecution because so many victims don't come into court. We can get the victim statements to the officers in. If she said something different to the officers than she said in court, we can get in whatever the officers saw about her demeanor, any physical evidence, if hair is pulled out, items are broken. We can also get in prior acts of domestic violence to show the jury that this is not just a one-time fight, that this has been going on for a long time, and we bring in witnesses. Next slide. Now, this is my favorite slide because when you are picking a jury, this is exactly what you get in the box. You get 12 people, you have no idea what they are, and you try to weed out the ones who are crazy, the ones who are from another planet. You try to weed out the ones who will not pay attention, who have some sort of prior agenda. You try to get rid of the ones that are crazy, the ones that don't speak any English. And it's a real hit and miss guessing game to try to end up with 12 people who are just willing to listen to the evidence. And you can hit it several times and you will eliminate some of the worst jurors.
And I'm going to keep on using my puzzle analogy. The burden that we have to prove this to 12 jurors unanimously is beyond a reasonable doubt. Civil cases, family law cases, dependency court cases, none of them have this burden of beyond a reasonable doubt unanimously. And you have to remember that when they come into court, they're presumed innocent. And it is our responsibility to show beyond a reasonable doubt that they did these actions. They start out with a blank slate, and all the jury can consider is what we present to them. They can't presume anything. And so all they have is the words that and the photographs, the statements that we give them. It doesn't matter what the victim says in court. We've been trained and we know how to work with what she says. If she recants, we know how to show the audacity of that to a jury. If she tells the truth, it makes it easier on us. However, it used to be it didn't matter if she showed up or not. And now, as Sharon said, with the Crawford case, without the victim, without seeing the whites of their eyes, the confrontation clause that we hear about on TV jury trial shows, the defendant cannot confront the person accusing them, and then we cannot proceed. Yes?
Do you take the opportunity to try to educate the jury on the cycle of violence? Do you bring an expert or something else so that the jury better understands the recanting and how that fits into the cycle of violence?
Are you volunteering to be an expert?
Well, then my other question is how are the children of the victim, if they are witnesses, brought into this process? Do they get to go to the judge's chambers to give testimony, or are they in front of their facing their perpetrator?
No, that's what it means. They're the accused has the constitutional, this goes back to the United States Constitution. He has the right to confront his accuser. So there is no taking the victim into the judge's chambers. It's eyeball to eyeball.
What about minors, though? I'm talking about a dependency court, the video camera set up so that
There can be accommodation made for children. Yes, there can be accommodation made to protect children. Yes. The what? I'm not familiar with it. Well, that's why I'm not familiar with it.
I don't know if it only applies to where the victim has been killed, or whether or not they're going to allow for other extenuating circumstances where the victim's not available.
I don't know.
I don't know about it either. I have a February 28th case here, but that's about as recent as I get right now. As far as a victim being killed, which first of all, that would not be a misdemeanor. And so with as much as we have in our brains, we have to limit ourselves. But unavailability has a legal definition as what is considered available and what is not. And death is unavailable. I think I've addressed this one, so if we could move on. If we could, okay, once we get a conviction, and this is where most of you come in, because this is where intervention in the family is this is our chance. The convicted person is put on 36 months of summary probation. When you hear probation, you think about reporting to a probation officer. Summary probation, you do not report to a probation officer. You come into court for progress reports where you show how you have been attending your counseling, if you're sent to a 12-step program for substance abuse, all of those things. And there is no electronic monitoring in domestic violence cases. You are either in custody or you're out of custody and you're in counseling. You are sent to a 52-week domestic violence class, and this is not babysitting, as most of you know. You must participate and get good progress reports. You cannot go and sleep for an hour weekly in a class. And if you're not participating and doing your homework, you get sent back to the judge and your probation gets violated. We're really trying our best to intervene. As we were discussing last week, we don't know how successful it is, but we do know that we're trying. You have 40 hours of community service. We know that there's a financial burden on a lot of families and we don't want to increase it, but you do have to pay a penalty to the community for violating a law. It's not just hurting your victim, but you're also breaking a law of the state of California. There are $435 in fines, which cover the costs of court services. A $200 donation to a battered women's shelter, and there's a list of the acceptable shelters. You can't just have your friend call his house a shelter. And there's the stay away protective order, which is given automatically, and if the victims do not want it, they need to come into court, speak with the judge, and give reasons for not wanting it, because we understand that there can be a threat upon a victim saying that you better go in and say that you don't want it. And a lot of times the judge will hear that with the defendant out of the courtroom. If you could click, please. Okay, additional jail time for people who have done some of these things which you might think felonious, which are not. Caltrans work, cleaning garbage on the side of the freeway. These are all additional penalties that we put on for people as things get worse and worse and worse, because there's only so much you can do to them. Anger management on top of their domestic violence counseling for people that don't just build up to violence but blow up. Restitution for property damage, 12-step meetings, and live-in drug alcohol treatment. And they do have in Linwood a program where you can actually be in custody and do a live-in drug alcohol treatment program. The one thing that we consider is a lot of people we don't put in jail that you think, why aren't they in jail? And that's because with a misdemeanor, the longest you can put someone in county jail on one single count is a year. And due to the overcrowding in the county jails, that year can turn into as little as a few days. And so if you put them in for the year and you spend your whole year, you don't get to intervene with the counseling. So we'd much rather have someone in counseling and trying and failing and sending them back and trying again and like knocking their head on the wall, if you'll excuse that, until maybe they hear something, because in jail, they're just meeting other people who are doing bad things and learning how to do more bad things. Click, please.
In our cases, if the victim is there on a first-time case and she does not want a protective order issued, most of the time we won't issue one. But if the victim is not there, we always issue the protective order that orders absolutely no contact. A criminal protective order takes precedence over any other order. So if your victim has gone to family law court previously and gotten some kind of an order, and then you have a domestic violence incident where a criminal court protective order is issued, that takes precedence over the earlier family court order. Most of the time, the defendant is served with the order right in court, as opposed to a lot of the family court orders, which have to be separately served afterwards. We are very lucky in Long Beach. We have a dedicated domestic violence court. It's a very special place. We handle all of the misdemeanor cases up to the time that they are in trial. We have a female judge who is very knowledgeable. She's been handling it for about 10 years. There's no nonsense, there's no whining, there's no excuses, the dog ate my homework. They have to report in every 2 to 3 months with their progress reports from the program. And we get lots of consistency and follow-up here in Long Beach that you don't get anywhere else that doesn't have a dedicated court. There used to be more, but we're really unique in that right now in Long Beach. Okay, our goal for victims' safety, we issue the protective order. For defendant accountability, that's the reason for the progress reports every other month. And our goal is to change behavior. That's the reason for the 52 weeks of counseling and the AA meetings or whatever orders are issued. We want to change behavior.
And as most of you know, a misdemeanor today could be a felon tomorrow, or a felon tomorrow could be a misdemeanor today. In the beginning of my career, I met a woman named Deborah Riles who had her shorts ripped. And he was in custody for a simple misdemeanor battery, 242. Not even a domestic violence charge. It was earlier when that crime was not around. And the next thing I knew, I was testifying in her murder trial. And he'd gotten out of jail, had his paper protective order, which is supposed to protect them. And horribly, he kidnapped her screaming through the open courtyard of her apartment building, and all they had evidence of that was the puddles of blood. And he jammed her in the trunk of the car and hit her with the tire iron as he drove around town. And every time he stopped to check on her, if she was awake, he'd hit her again. And she didn't die from the tire iron or asphyxiation. She died drowning in her blood. And so I'll remember Deborah forever and realize that just because it's very important what we do, because just because they do a misdemeanor today doesn't mean that they're not going to do a felony tomorrow.
Both had our own defendants, misdemeanor defendants, go on to kill their victims. And you realize when you do this that every case is a potential homicide. Every single case is a potential homicide.
So frequently we see domestic violence, spousal abuse, which is, I think, now it's between both gay and straight partners. You must reside in the same home or have a child in common. Battery, which is is just unwanted touching of another person. The relationship is not in that description. A dating relationship where you're in a relationship but you do not live together, or there is not a traumatic condition as the result of the violence. 591, I believe, is where you cut the telephone cord and they're not able to call for help. Vandalism, ruining things in the house, throwing things around, violating that little piece of paper, the protective order, violating the restraining order, which is from the civil court, child abuse, which includes domestic violence in the presence of a child, not just hurting the child, but when the child is present. Stalking, criminal threats, which the victim must take seriously. It can't just be, I'm going to hurt you, but the victim's hearing it is very important. Does she take it seriously? assault with a deadly weapon, hitting her or with an item, brandishing a weapon, threatening her with a weapon, not the contact, threatening phone calls, and aggravated trespass, coming in when, like breaking down the door and coming in, even though you are unwanted. Click, please. Why we reject cases we spoke of earlier, so I'm just going to go through this really quickly, but there's no injuries, no one to corroborate, no physical damage, no damage to property. It was not any physical violence at all, but simply a yelling and screaming in public based upon transfer of a child. Restraining order violation, but the defendant did not know that there was a restraining order. He had never been served with it. Mutual combat, meaning that they're fighting with each other. You don't really know who was the aggressor. Equal back and forth with no witnesses. And unfortunately, hostile divorce behavior, where it's the breakup of a marriage and it's not really one person victimizing another, but again, more of a mutual combat situation. And Sharon and I, not to toot our own horns, but we do believe that domestic violence prosecution is not for every prosecutor. It's for a person who's willing to take the time to come to groups like this and continue their education as the field grows, to learn that I should be using the word survivor and not victim, and to make contacts with all of the social services so that we know how to intervene and how to help, how the field is growing. A lot of people who are not interested in domestic violence consider the victims whiners, and they don't want to hear it. They don't want to deal with all the nuances of getting into people's personal lives. On the other hand, it's so rewarding because of people like Angie, survivors who put the smile on your face, where you know that you can actually affect someone's quality of life. And I'll let Sharon finish up here.
Okay, well, I know we've gone way over. As you can see, June and I can talk for hours on this. You know, we need an egg timer to stop us. Any questions? Anybody have any questions? Yes? Well, June's office they sit right next to us in the courtroom. So the people that you talk to sometimes are June's victims. So, yes. Yes.
You mentioned you have victim advocates.
Yes.
Have they been trained in domestic violence and assist the policemen who provide the homes and take the videotapes?
So far, that has not worked out. There are liability issues. There are issues of them getting in the way. There are issues of potential danger to them. Plus, the advocates really don't want to be there with a camera in the face of the victim. They want to be there to assist the victim and bond with the victim and get the victim what she needs, not to potentially put her in a hostile relationship by putting that video camera in her face. Yes.
Because it is so hard to get convictions, how does that affect your viability to work in general? I mean, don't you get pressure from your supervisors, conviction commissions?
The DAs do, and that's one reason why they don't file them. Fortunately, in the city prosecutor's office, and I think in the city attorney's office, we don't get the pressure, and you have to have the mental defect that makes you want to keep on hitting your head against the wall with no reward and no thank you and no appreciation, and just keep hitting your head against the wall because it feels so good in order to do this.
And, sorry. I should say in our office right now, we're also going through a huge reorganization because we found that since the Crawford case, our caseload has really decreased in domestic violence because of if you do not have a victim who's willing to come in. And they're actually lessening the domestic violence positions because you cannot take a case to court without a victim.
Are the videos admissible in court? Because, you know, this is one, as I'm watching this and I think about our system, you're taking a physical event where a picture is worth 1,000 words, and where the photograph or the video is so much more compelling than a victim trying to turn that into a narrative. A verbal narrative is like so diluted. If you were able to get those videos, are they even admissible?
Well, if you have the victim there, then you could get them in. But without the victim there, the accused person has no right to confront their accuser, because by showing the video, there's no opportunity for cross-examination. And that's what's missing.
The
So
whole,
that's-
the whole point of this confrontation clause is reliability of testimony. And the way that you gain reliability is through allowing cross-examination. And so therefore, without the right to cross-examination, the evidence is no longer admissible.
Last question.
So in that case, since she was there in court, were you able to use that video?
We did. We used the video, we showed the video, and what I clipped off, because we didn't have time for it, is we interviewed about 7 of the jurors afterwards who all said, without that video, we would not have given you a guilty verdict. They did convict the guy, but it was based on the videotape. And they all said if we had not seen her at the hospital, we would have voted not guilty. So it's a powerful thing, and I still am an advocate for it. If I could, if there was some way to fund the police department to do it, we would have a lot more convictions.
Well, I thank you all for staying till 10 o'clock, and I certainly thank both of you.